Alrighty, good evening, everyone. Welcome to week 4 of administrative law. Really important week from, if nothing else, from the perspective of your midterm assessment. So, well worth putting a lot of focus and energy onto this one at this stage in the term. We're of course talking about merits reviews. So this is the stage in the administrative law proceedings where, if it's available to us, and it's not always available, and we'll talk about that, but if it's available to us, merits review is a really important and really useful strategy for getting an administrative decision reviewed and having another chance to look at it. Your midterm assessment, the MOOT, a key component of that looks at the review of a merits review of the decision not to disclose documents under a Freedom of Information request, and the decision not to approve an applicant's disability pension applications. So whether you're senior counsel or junior counsel, you'll be considering the merits review process and considering the arguments that get put forward at merits review. Either if you're on the applicant side, forwarding those with a view to changing those decisions. And if you're on the respondent side, talking about, why the decisions that were given should be supported or upheld. So really, really important considerations. And I think the best way to address that and get a sense of that is to dive into this week's hypothetical question, do some brainstorming around that, and then look at crafting those merits review arguments. Before we do that, though, the one, I suppose, key point about merits review that I really, really wanted to emphasize, it's all pretty important, but the key thing that I want you guys to take away is to think about the standard set out in Drake and Minister for Immigration and Ethnic Affairs, the correct or preferable test, right? Thinking about whether a decision is correct, as in there's only one right answer, or whether it's preferable, as in thinking about whether there's subjectivity and discretion. Really, really important for you guys to be able to identify within a decision itself whether there is only one right answer, right? If the primary legislation directs you towards a particular answer or particular conclusion, and therefore the argument is whether that process has been followed properly or not, the decision is therefore then either correct or incorrect, or whether there is flexibility, subjectivity, discretion, in which case your arguments are going towards the preferableness of a decision. And it's absolutely critical that you can successfully identify that distinction, because that needs to inform your arguments that you're presenting at the moot to the tribunal, right? If there's only one right answer, then your submission needs to be directed towards logically stepping out, look, here's A, B, C, and D. So the only correct conclusion that you can reach is E. That's a very different set of arguments and a very different way of approaching things than to say, look, we acknowledge that there's subjectivity and discretion here. A is open to the decision maker, but B is open as well. We present these arguments, and for these reasons, we say that A should be preferred to B. It's a different approach. It requires different arguments. And so it's really, really essential that you guys are familiar with Drake, are familiar with that correct or preferable test, and are able to use that to inform your approach to those arguments that you'll be presenting at the moot. Does that make sense? Awesome. All righty. So we'll were there any questions before we move on? Awesome. So we'll We'll start with question 1, just a quick discussion around the advantages of having the AAT. We might skip question 2 and circle back to it at the end if we've got time, and then we'll move on to question 3, which is that hypothetical, and we'll spend a lot of time on that one. But let's start with question 1. What are the advantages to having the AAT review a decision instead of the courts? Why would we even bother going down this path?
More cost effective, less stress on people. It's less invasive, I suppose.
Yeah, so the cost is obviously a big factor. Thinking about it's certainly not an informal process, but there is less formality around it than going through a judicial review through the courts, and that can reduce stress and those sorts of factors as well. Yeah, absolutely. What else?
It holds the executive to account in a way that's more, I suppose, accessible to the average person.
Yeah, the accessibility aspect of it is really important, and to the extent that while yes, both the AAT and the courts look at holding the executive to account, the cost and the flexibility of the AAT does make it more accessible, and therefore does give more opportunities to hold the government to account. Absolutely. There's probably one other, there's a few other advantages, but one really big one that I'd like to make sure we cover.
The scope is broader, so it's looking at facts and law, whereas if you go to the courts, you're just looking at whether the decision was a legal decision, and so it's broader in that sense.
Yeah, absolutely. So, and then sort of on a similar note in the chat, Malik has said that, yeah, you can look through the facts. So there's a broader scope, and then Megan has added as well that the AAT can look at the information afresh. And so combined, those points are all really useful because it means that we can get a fresh look at everything. And if it's a de novo hearing, we can even look at new information that wasn't before the original decision maker as well, right? So this is
add the de novo.
Yeah. And so this is really powerful because the important as the courts are, they are limited to questions of law or process, and they're really reliant on the original decision maker, what was in front of them, the facts that they brought to it, and the processes they took as the starting point. Whereas we've got, if not a blank slate, at least a fresh chance at merits review. So that's really important. And then on top of that, Stephanie's noted in the chat that the merits review, you can actually change the decision as well, right? And I think even if all the other stuff was put aside, the fact that we can actually get a fresh decision from the AAT is kind of worth going through merits review on its own, right? The ability to get a decision maker to appear in front of a decision maker, make your case, and then have them then and there, make that decision. That's so important, right? Under judicial review, the best that you can get is you point out the problems with the decision, and they send it back to the decision maker to have another chance at maybe getting it right the next time. Or there's the risk that they make the exact same decision the same way, they just do it properly or a bit more rigorously the second time round, right? Whereas with merits review, that chance to get a decision then and there is important in its own right, and also, is makes things more efficient and potentially more cost effective as well. So yeah, some really big benefits to the merit review process and to the AAT in particular. it's worth keeping these things in mind as you go into the moot assessment. You know, you're not going to get up in the moot and you talk about the cost effectiveness of the AAT or anything like that, but it is worth keeping in mind, you know, these benefits of looking afresh at the facts and looking at new facts, the opportunity to actually seek a change decision. Those are benefits that should inform your approach to the moot. Obviously, if you're the applicant and you want a different decision, that's going to be big. But equally, if you're the respondent and you want the decision to stay as is, being aware that the applicant is going to try and get a change decision affects the way that you approach it as well. You got a question, Emma?
Yeah, I was just going to say, how do you actually refer to the person in the tribunal? Like when you go in and you're talking, what do you refer to them as, ma'am, or?
It's a good question, and you know, when it's a court, it's fairly obvious, right? I think we would all know that it's Your Honor. At the AAT, we've got, so sort of the levels are member, senior member, deputy president, and then president, and you refer to them as that title. So president, senior member. Member is potentially an exception, just because it's, you know, a little bit weird to refer to someone as a member, innuendo aside. So you can also refer to the tribunal and a member by their name and title. So, you know, Mr. Smith, Professor Brown, whatever it is.
We don't know who you'll be when we do the assessment. Will you have a name tag, or do we just refer to you as Jacob?
Well, we're not on first name basis. I think I'll double check. I'm pretty sure I've put in the facts that you're appearing before tribunal member Deem. So you can say, you can call me, I mean, I don't mind. You can call me a member, especially after you've got your grade. You can call me Dr. Deem. You can call me member Deem. You know, those options are fine. And you know, I was going to say the tribunal members don't take themselves too seriously, but they do. And it's important that you, I suppose, follow the proper etiquette. They're for self-represented litigants, they are a bit more flexible, I suppose. You know, they when someone accidentally calls them Your Honor or whatever, they let it slide. But for people who are legally trained, there is an expectation of a higher standard. So it is worthwhile practicing that etiquette and trying to get that right. So yeah, Dr. Deem, member Deem, those are the key ways to go about it. Any other questions before we keep going? Awesome. All righty. Well, let's jump into question 3, because I think it's really important that we have a good conversation about making these sort of persuasive merits review arguments. So this scenario refers to, and this act isn't, well, it's not completely unreal, but it's an amalgam of state and federal laws and stuff. So don't actually go and try and look this act up because you won't find it. But the Security Personnel Act 2015 is administered by the Chief Executive of DJAG, and it establishes a scheme to license and regulate security providers, so bouncers, security guards, those sorts of jobs. Section 10 provides that you can't carry out those functions unless you have a license. And then sort of Section 11 sets out the process for getting that license and the key considerations on whether someone should be granted a license or not. Section 12 elaborates with some inquiries that can be made. Section 26 refers to appeal to the AAT, and there's a typo in paragraph 3C. It refers to directions which the court considers appropriate. That should obviously be tribunal. Our facts are that John has been unemployed for a few years and he recently did a training course for security guards. At the conclusion of the course, he applied for the license. The chief executive wrote to Mary, his employment services case manager, and asked if she thought that he was an appropriate person. She replied that she'd referred him to the course and she thought that he was appropriate, but he has a problem with chronic lateness. The chief executive also asked for his criminal history, and there was a bit of a mix-up. John himself has never been convicted of an offence, but by mistake, they sent someone else's criminal record and it showed that he had a criminal record, so that was a problem. As a result, the chief executive wrote to John saying that the application had been refused, the reasons being: 1, he'd been convicted of an offence; 2, he lied on his application; and 3, you would not diligently carry out your duties should you be employed as a security guard. Advise John, and in particular, we'll think about this process for merits review. So I'd like to start, as always, with a little bit of brainstorming around what our initial thoughts and reactions are to that question.
Sort of identity confusion, I suppose. So we're really arguing that, it's not based, we're bringing new facts because we're going to be saying, well, there's been an error.
Okay, so thinking about fresh evidence and the fresh evidence being John's actual criminal history, which will show that he hasn't been convicted of an offence. Yeah.
Right.
What else?
Probably need to bring some evidence of his, of his status as, in terms of character references and things like that. Might be able to be supporting. I don't know if that's something. Or do you just base it on the facts that we've got, but just to prove his credibility? And
that's a good question, and the main I suppose reason I want to answer that is because as far as it's relevant to your moot assessment, it's important not to go beyond the facts that you're given, but there is room to plausibly read between the lines within the facts. And so, I wouldn't, to take this scenario as an example, if you were mooting this, you wouldn't in the moot get up and say, oh, and we'd like to introduce this fresh character reference from John's old boss, Steve. Steve says he's a really great guy. Or so, we wouldn't. I think, and I'm not suggesting that that's where you were wanting to go with that. I think in reality, looking at other evidence of John's character might be a useful way of approaching things from the perspective of this unit, and in particular the moot assessment. You wouldn't be looking at going out and getting fresh stuff, but what you might do is, within reading between the lines of the facts that we've got, what you might do is focus a little bit on the statement that Mary has made that she thinks that he is an appropriate person. And so there's clearly evidence within the facts already that there is those elements of his good character have been established. What else?
it's hard when there's only a few of us online.
Yeah, absolutely. Yeah, it is. It is a bit tricky. Why don't we start then with, I suppose, thinking about some of the more preliminary issues. So I've already sort of flagged that we're thinking about the AAT and merits review. Why is that an option?
just because it's an executive decision that's been made.
Uh,
There's within the legislation, they also give there's the right to appeal to the AAT within the legislation.
yeah. So that's the key. That's the key part, right? Thinking about Section 26(1)(a) of that Security Personnel Act allows for AAT review of a refusal to grant a license. So that provision, in conjunction with Section 25 of the AAT Act, allows for a merits review by the AAT. So as a threshold issue, being able to identify and explain that that's the process that we're going to use for the merits review is an important, I suppose, process to have down pat.
So would you say in that scenario, Jacob, something like, so Your Honour, oh, not Your Honour, Dr. Dean, this qualifies for a merits review, taking into consideration the legislation supporting this Section 26(1)(a), as well as Section 25 of the ADGR? Is that how you'd sort of put it?
I would. So 25 of the AAT Act.
Sorry, AA.
Yeah. So there's, because the two sections sort of fit, you kind of need both. There's probably a little bit of flexibility in the way that you structure it, but yeah, something along the lines of, look, Section 25 of the AAT Act allows for the AAT to conduct a merits review where the primary legislation allows. In this instance, Section 26(1)(a) of the Security Personnel Act provides that authority to the AAT, and it's on that basis that we make this application. Something along those lines. I won't go too much further, because that starts to then, I'm conscious that feeds into the midterm assessment pretty well. But broadly, that's what you're looking at discussing. All right, so we've established that we can be at the AAT. Once we're there, what's the standard? What's the AAT looking to do in the end?
They'd have the submission, so they'd be looking then to the parties to speak and provide their views or why they're there.
Yes, yeah. Sorry, I should let me rephrase. What's the end goal? What's the end point for the AAT in this review? Where are they likely to end up at the end of this?
Making a decision whether the decision's been made inappropriately or against the available legislation.
Yep, absolutely. So in particular, thinking about in the Security Personnel Act, Section 26(3), the AAT can confirm the decision, set it aside and substitute another one, or set it aside and return it back to the decision maker. So that's fundamentally, that's the core question that the AAT will need to answer is, what should it do with this decision? And the way that it decides what to do, obviously both parties make their submissions, but what's the test, or what's the standard that it will use to help it make that decision? A key case that we talked about earlier.
A correct and preferable decision.
Right. Yeah.
Drake.
Yeah, absolutely. Sorry. For those of you on the recording, my toddler brought home a cold, so we're working through that one. But yeah, so correct and preferable test from Drake is the key standard that we're looking at. And so what we need to step the tribunal through in making our submissions, making our arguments, is what is the correct or what is the preferable decision? And on the basis of that, does the tribunal need to set the original decision aside, make a new one, send it back to the decision maker, all that sort of stuff?
So can I ask a question? Would we
Yes.
actually say what our preference would be, like, or is that inappropriate and we leave it up to them, as obviously they know what they can do? So would we say we'd like you to set this decision aside, or is that something we should just leave out because they know their job? And
Yeah, no, great question. You definitely ask, because if you don't ask, you don't get. So yeah, you ask, and the reason why, obviously, you know, intuitively they do know what they can do, but the reason is that what you're asking for will inevitably affects the way that you go about asking for it. And I mean, it's in a scenario like this where it's quite simple, the distinction is maybe not so clear, but in a matter that was a bit more complicated, let's say you had a tax dispute, right? And there was, you know, the key issue was whether a particular source of income should be treated as taxable income, or a key expense could be claimed or not. And so the decision that you're chasing is not so much, you know, do you owe tax or not, but around the exact amount of tax, and where the amount of tax is in dispute. And you'd be really clear in saying, we're asking the tribunal to declare that the taxable amount is 50,000, where the original decision was 60,000 or something. And where, you know, the commissioner might be arguing that actually it should be 70,000. So kind of both parties are arguing for the tribunal to set the decision aside and put a new one in, but the dispute is around just what that new one should be. So being really clear about what you're asking for is really important, and goes into your submissions. Absolutely. As I said, in this sort of an example where it is a bit more cut and dry, the distinction is less clear and maybe less important. But yeah, absolutely. Be nice and clear. What do you actually want the tribunal to do about this?
In the submissions, we obviously use Drake and all of that when we're writing it in, but like when you're actually in a tribunal, you don't refer to case law, do you? Like I tried to go to one, but they say they're all private and it's really hard. I tried to go and watch one, but yeah, you don't use the case law in the actual hearing.
Yeah, so that's well, let me answer from the moot. For the moot, yes, refer to Drake, because I mean, look, it's no great, it's not giving too much away to say there's a few marks in it for correctly identifying and applying Drake, right? So from the perspective of what is on my marking rubric, I need you to direct the tribunal's attention to Drake and talk about that. In practice, yeah, look, you know, they all know Drake, they all know the standard, and so there's not a strong need to, you know, tell the tribunal member about Drake and what it is and what it means. And so yeah, you know, you wouldn't waste their time doing that. Where there might be some discussion is, you know, whether the decision that you're reviewing is incorrect or not preferable. You might have a bit of a discussion about that, but yeah, you know, they don't need it spelled out to them that that's the standard or anything like that. But for the moot perspective, yes, you absolutely need to cover that. Cool. So we've set out that we want to be talking about Drake. We want to be thinking about correct or preferable. Can someone quickly refresh our memories? What is the difference then between correct versus preferable?
So from what you said before, the correct decision is either a right or wrong decision, and the preferable decision is a decision that's based on where the decision maker has more discretion and it's more subjective.
Yep, absolutely. And
So
so
is that actually like a law as opposed to like a decision based on the law would be right or wrong? Is that law versus what am I trying to say? Yeah, I thought it was, is it correct according to the law, or is it preferable because of, is it the best decision that could be made?
I think thinking in those terms is generally fine and will generally lead you to where you need to get. They tend not to frame it in exactly those categories, just because you can sometimes get a decision that even on the law has elements of discretion, and we'll talk through. May as well talk through this scenario as an example to think about the distinction. What's maybe a more useful way of thinking about it is to look at that primary legislation and look at how much direction it gives to the decision maker in terms of what factors can go into the decision, how they need to go about weighing different elements, that sort of stuff. And so, for example, so section 11(1)(a), a person's entitled to the license if they're satisfied that you're 18 or above, right? That's pretty cut and dry. Someone's either 18 or they're not, and therefore that's the decision about whether they're 18 or not goes to the correctness, right? They either are or they aren't. The 11(1)(c), and we'll talk about this in a bit more detail in a moment, but is an appropriate person to hold the license. That is a bit more open, and paragraphs 2 and 3 go through then the kinds of things that can lead you to a conclusion about someone's appropriateness, but there's more flexibility there. There's maybe room for a bit more subjectivity, and because of that, I'd say that 11(1)(c) speaks more towards the preferableness of a decision, and you'd be making arguments about whether it's preferable to find that John is appropriate or not. Whereas, the whether he's 18 or not, whether they've successfully completed that training course, those are yes, no, right, wrong, those sorts of things.
Yeah, thank you. That makes it a lot more clear for me.
Cool. Okay, that's good. It's good that it's clear now,
Yeah.
because we're about to make it a little bit murkier by looking at paragraphs 2 and 3. 2, 3, and 4. The reason being because they're given some direction in terms of what whether a person's appropriate or not. They are limited to considering matters mentioned in subsections 3 or 4. That means that if the decision maker concluded that someone was not an appropriate person based on something outside 3 or 4, that's actually an incorrect decision rather than not a preferable one, because there's no discretion about what factors to include outside of sections 3 or 4. Does that make sense? I'll phrase it in another way. So you've got, if the decision maker decided that John wasn't an appropriate person because he had blonde hair, that's something that's not mentioned in subsections 3 or 4. So subsection 2 says you can't consider that, right? In deciding if someone's appropriate, that's not in 3, that's not in 4, therefore you can't consider it. It can't be part of the decision. And so if the decision included that, that's wrong and there's no flexibility there. If John, if they only talked about or only looked at issues within 3 and 4, so the dishonesty and integrity, the harassing tactics, the criminal offence, those sorts of things, that could be correct in the sense that it's followed the objective requirements that are set out in the legislation, but it might not be preferable in the sense that the conclusion that they reach about whether there's dishonesty or integrity and those sorts of things, there's subjectivity and flexibility in how much weight to put to those kinds of things and deciding whether that makes someone appropriate or not. I'll give that one a minute to
So then when they say you would not diligently carry out your duties, I'm assuming they're referring to Mary's comments that he goes to, he's often late to work or late to his appointments. Is that something then you use as in saying sort of that goes beyond what they're allowed to use to make a decision in 3 and 4?
Yeah, well, so we'll talk about that's, I'd say that's now going to the next step. So before we move to that one, is everyone cool with where we're at the moment in terms of if it's outside 3 and 4, it's not correct. If it's inside 3 and 4, it might be correct, but not preferable. When we then think about these statements, the statement about to Mary around, he's late all the time, and presumably the conclusion that the decision maker has reached in terms of whether they would diligently carry out their duties as a security provider or not. If we were acting for John, we could make 2 arguments in parallel. The first could be 3. I mean, 4 is the criminal record stuff, so let's ignore it for now. 3 doesn't say anything about a person's diligence. It talks about dishonesty and lack of integrity, and it talks about harassing tactics and criminal activity. None of that is diligence. None of that is lateness. So to the extent that that's what the decision's been based on, that's not in 3 and 4, and therefore it's outside what the decision maker can consider, and it's incorrect, right? That could be argument 1. It's not a correct decision because this conclusion about diligence is not in the list of things that the decision maker can consider. In parallel, you could make the argument and say, even if that is inside 3 and 4, right? Even if we accept that diligence is important to, let's say, dishonesty and lack of integrity is probably the closest fit. Let's say that the chronic lateness shows that he's dishonest and lacks integrity, and therefore it does fall within 3, and therefore can be something that the chief executive can consider. Even if that were the case, we would submit that the lateness to the job, the case management, employment meetings, whatever they were, doesn't prove or doesn't in any way reflect the way that he would carry out his duties as a police guard, as a security guard, and that, you know, his performance during the training course is a much better indicator of his diligence, his honesty, his integrity. And therefore the preferable conclusion is to decide that he is appropriate, because those factors should be preferred over this offhand comment about he's late sometimes. So you could make alternate arguments and say, look, our first position is that it's outside the scope of 3 and 4 and therefore is not correct. But in the alternative, if it is inside the scope of 3 and 4, it's still not even preferable. Are we happy with that one? I know that that's, you know, we're going through a lot of sort of layers of interpretation and argument there. But I think it's important that we sort of get that down pat, because that's, I think the moot is not quite as complicated as that one, but it shows you the kinds of thinking that you can be applying to the moot scenario around, you know, is the issue with this decision one that speaks to its correctness, or is this an issue that that speaks to whether it's preferable or not? And the way that you answer that will affect the way that you present your submissions to the tribunal in your moot. So it is really, really worth thinking about the distinction and the way that you frame the issue, because, you know, as you can see, that impacts the way that you argue the case. So that's, you know, those, we've really focused there on maybe this idea around the sort of the third point around whether he would diligently carry out his duties or not. Can we have a go at applying similar sorts of reasoning to that second point? You lied on your application. How would we go about unpacking that aspect of the decision?
Well, that's just a misunderstanding, isn't it?
Yeah, so we would argue that that's incorrect because the facts are incorrect. The facts that they've used to make the decision are incorrect because they've used, you know, the criminal record from a different person.
Yeah, okay. I like the direction. I like the argument. Let's take the next step now and think about how we frame that with reference to the particular sections, the subsections of section 11.
So would we say something like, you know, the decision was based on section 11(3)(b), however, that decision was incorrect because our client or the person that we're arguing for doesn't have a criminal record?
Yeah, so there's a few ways that we can sort of slice it up. The first being the correct decision would use the correct criminal history record. You know, it wouldn't be based on someone else's. The other issue that's potentially in play is, you know, the idea that he's lied on the application therefore shows under 11(3)(ai), he shows dishonesty and a lack of integrity, right? You know, if he actually had lied on the application, then it would be pretty reasonable to conclude that he's dishonest. But the fact that he hasn't, we could make the parallel argument that the preferable decision, having used the right criminal record, which shows that he doesn't have one, the preferable conclusion is therefore to decide that he does have honesty and integrity and is appropriate.
You could say something like, look, I asked you to consider the reverse, given that the incorrect criminal history was provided, that this is no longer applicable. Would you say something like that, and that you see it as a more preferable, something along those lines?
Yeah. So it's sort of similar to the previous section where you've got those kind of arguments in parallel. First argument being it's not the correct decision because it hasn't used the correct criminal records. In parallel, it's not the preferable decision because on the facts that are before the tribunal, which presumably are his actual criminal record, the preferable conclusion to reach is that he does have honesty and integrity and that sort of stuff. So that one's kind of got the dual argument because the Act specifically calls out criminal history and criminal record as being something that is relevant and can be considered. But it's also got that dishonesty and lack of integrity where there is that flexibility and subjectivity. But yeah, you're broadly arriving at a similar style of argument in saying it's not correct and it's not preferable.
Okay, so if we look at why the application was refused, you've been convicted of an offence, so we would say that's an incorrect decision and give the arguments because of reasons we've discussed. You've lied on your application. Again, there's an error of fact there, so it's incorrect. Again, for the same reasons that they're using the criminal history of someone that's not this person. So we're really arguing for the third point. You would not diligently carry out your duties should you be employed. So that's where we go into that more talking about whether the decision was made was preferable. Is that?
Yeah, and it might be helpful in that regard to, I suppose, take a step back and think about, okay, if we were the respondents to this, if we were the counsel for the Department of Justice and Attorney General here, what would we be arguing? The stuff around the criminal offence is pretty tricky. So that's, I think you wouldn't even bother with that. You would have a lot more flexibility or a lot more scope to argue that the diligence, the lack of diligence carrying out duties speaks to a dishonesty and a lack of integrity, perhaps. I don't think that that's necessarily a strong argument, but that would be the best one that you could make. And potentially, that you lied on your application, that very much seems to be directed to the criminal record stuff. But you could also, I think, make the argument that if you were counsel for the respondent and needed to, I think you could make the argument that the making of the application, even when he, probably would be late all the time and wouldn't diligently carry out his duties and all that sort of stuff, shows dishonesty and lack of integrity. And so there's the most scope to argue on the third point. There's maybe a bit of a scope to argue on the second point. And so thinking about it from the respondent's perspective guides us as counsel for the applicant to think about, okay, where do we need to put the most effort in? Where do we need to have the most discussion to present the compelling case? So I suppose with all that in mind, I think we've come up with some pretty compelling reasons to say that there are problems with the decision. How would we then go about, and we've talked about this a bit already, but how would we go about spelling out to the tribunal what we're hoping to get out of this, and how would we sort of frame those arguments?
I suppose we got a lot of little yeses along the way, because we've sort of proven that, you know, there was a misunderstanding and the incorrect information's been given. So based on the fact that we've been able to ascertain that our client meets these requirements, you know, then go for the preferable decision being to reverse it or, ask for closure and commitment.
Yeah, absolutely. So, and again, right, it's important that we're thinking about this in terms of the primary legislation and the sections of the primary legislation. So directing the AAT to section 26(3) of the Security Personnel Act. And in particular, 3B, we're looking to set the decision aside and substitute another decision. And in particular, the decision that we would like substituted is a decision to grant the application for the license. What's relevant is to note subsection 4, that the AAT has the same powers as the chief executive. And if they substitute another decision, it's taken to be the decision. So why that's relevant is we couldn't ask the AAT to make a decision that the original decision maker couldn't have made. So, you know, we couldn't ask the AAT to make a decision that he gets the license and gets his registration fee for free for 2 years or something. We can only ask for what the original decision maker could have made, and in this instance, you know, it's grant the license or not, and we would like the license to be granted in this instance. Yeah. Yeah. Any other questions or thoughts or comments on that one?
I'm glad we went through that, because it's actually a lot more complex than the answer is a lot more complex, and the way you can argue it is a lot different from what I was imagining at the start of the tutorial.
Yeah, it's and you know, this is why I think the moot, in some respects, the moot, you know, the midterm assessment scenario is not quite as complicated as this one, in terms of, I think there's less need for those parallel arguments and stuff. It's a bit more clear what's correct and what's preferable. But it's a bit more complicated in the sense that, you know, I've tried to make it a bit more balanced between what, you know, factors that favor the applicant's point of view and factors that favor the respondents, so that, you know, trying to give you guys, you know, no matter what side you're on, you've kind of got you're in with a chance. And so that balance makes things a little bit trickier and a little bit more complicated to work out, you know, what you need to ask or what you need to argue. But in terms of, you know, where the complexity came in with this scenario, I think there's less of it in the moot assessment, but the critical thinking, the creative approach to the arguments, the thinking about how you frame this as correct versus preferable, all of those things are really important, and being able to approach the moot submission from that basis is the way that I would suggest going about it. In the chat, Stephanie's asked, do you get an apology at all? No, as an exercise in PR, sometimes if the case is high profile enough, you might, but it's not something that the tribunal or a court would direct the decision maker to make. It's something that the department would, and we could get our tinfoil hats on and say that that's because the government doesn't like to admit they're wrong, which I don't think is fair. I think sometimes they do, but often the concern is the precedent that it established. If a decision maker were to apologize, it would be an admission that they made the wrong decision, and it would potentially open up a can of worms for challenging other decisions, and they would be hesitant about doing that. So it's not something that the decision maker could be compelled to make, and it's also very rarely something that they would do off their own bat. And I think as a matter of administrative fairness and good governance, there probably is room for more apologies, but yeah, it's not something that we see very often.
So can I just ask if
Yeah.
so I'm the senior counsel for the FOI part, so the first part. So I would argue my case, and then would it go to the person? So do you do senior counsel, junior counsel, and then go to the opposite side, or senior, junior, junior?
Yeah, so you go senior, junior, senior, junior. So senior applicant, junior applicant,
Yep.
senior respondent, junior respondent.
Okay.
I don't know if you guys have had a chance to see yet or not. I've posted up a video going through a lot of the moot stuff. So there's about 20-25 minutes discussion of kind of what the moot is, how you go about it, some of the etiquette, the process in terms of that. And then I do a quick example of appearances, and then what senior counsel for the applicant, what their sort of submissions would look like. So if you haven't had a chance, go and check those out. One point that is worth thinking about, though, in terms of the difference between senior and junior counsel and the issues that you'll be talking about. So senior counsel for the applicant and respondent are debating or mooting the issue of the FOI application. And so what you're doing is you're thinking about these merits review principles and Drake and everything that we've been talking about today, and applying it to the FOI Act that we talked about last week. So these ideas around what's in the public interest, are there any exceptions that apply, that sort of stuff. Junior counsel is mooting the issue of whether the pension application should have been approved or not. And so again, it's those merits review arguments, applying Drake, all that sort of stuff, applied to the Social Security Act that's given in the scenario. So doing something similar that we did tonight in terms of, we've got a bit of legislation, a bit of primary legislation, and we're applying the provisions that have been given to us in the scenario. So it's the same exercise in terms of merits review, just different primary legislation. Senior counsel, FOI Act; junior counsel, Social Security Act, Social Services Act.
And can I just clarify one more thing? So
Yeah.
would it be, so it's appropriate to then anticipate what the other side would argue, and then put that within my argument, because obviously you can't speak after they've had their turn to
Yeah,
look
yeah.
at it.
It's,
So,
I mean, you've only got 5 minutes, so you wouldn't go too overboard. But it's certainly, in terms of thinking about the scenario as a whole, and the context of, so you said you're senior counsel. So thinking about FOI, thinking about, okay, there's questions of what's in the public interest here. These are the reasons that I think this would be in the public interest. What's the respondent likely to say that it's not in the public interest? And you can be thinking about those types of issues and ideas and using that to inform your argument. But I would probably, just because you've only got 5 minutes, I would avoid trying to go into a huge preemptive rebuttal of what the respondent is likely to say. The other thing that's, I mean, in terms of the moot itself, and I'll speak to this maybe a bit closer to the time as well. You obviously you're trying to give a robust account for your client and make a persuasive case, you're trying to be more convincing than opposing counsel. But it's at the end of the day, this is an assessment exercise, and I'm assessing you on your ability to find and apply the relevant legal principles, present a persuasive argument, present a critical analysis of the facts. I'm not trying to find a winner and a loser in each moot, right? It's possible that both sides perform equally well, ideal scenarios, all 4 of you get HDs, right? The reason I say that is I don't want you to necessarily feel too much like you need to, outplay the other side or out argue the other side. You need to work to create a persuasive argument for your side, but it's not a competition between the two sides, if that makes sense. And the main reason for that, as I've said, is my focus is on giving you guys a fair mark, rather than trying to decide a winner and a loser. But also, I think it's a stressful enough exercise as it is, without worrying about, are the other side going to be better than me or not? And so I don't want that to be an additional source of stress for anyone as well. Any other questions or comments? Because I'm conscious that this is, you now technically have all the material in front of you that you need to do this task. Next week we start talking about judicial review. So you've got everything in front of you that you need for this task now. So if there are any questions, now's a great time, or email me over the next few days. I'm looking at so next week we've got week 5, and then we've got the sort of vacation week. Not that anyone can go anywhere. I'm looking at that week at holding, I suppose, an informal tutorial session where, if anyone is around, you can drop in and ask questions about the moot assessment as well. So that's something that's on the horizon as well. I'll post an announcement up on Moodle about that within the next week. But if you've got questions or concerns about the moot, don't wait until then. Definitely do get in touch beforehand as well.
You've been very helpful, Jacob. Thank you.
No, that's no worries. I mean, I know that this is probably a new exercise for probably all of you. And I want it to be one that you can, the gold standard will be enjoy, but at the very least, get something useful out of. So yeah, more than happy to answer questions and hold that extra session as we go down the line. But other than that, we might call it there for this evening. Thanks everyone for coming along. I'll see you next week to talk about the first stages of judicial review. See you then.
Thank
Bye.
you.
Thanks.